Yet this rule admits of exception, where the former determination is most evidently contrary to reason, much more if it be contrary to the divine law. But even in such cases, the subsequent judges do not pretend to make a new law, but to vindicate the old one from misrepresentation. For if it be found that the former decision is manifestly absurd or unjust, it is declared, not that such a sentence was a bad law, but it was not law, that is, that it is not the established custom of the realm, as has been erroneously determined. And hence it is that our lawyers are with justice so copious in their encomiums on the reason of the common law, that they tell us that the law is the perfection of reason, that it always intends to conform thereto, and that what is not reason is not law. Not that the particular reason of every rule in the law can at this distance of time be always precisely assigned, but it is sufficient that there be nothing in the rule flatly contradictory to reason, and then the law will presume it to be well founded. And it hath been an ancient observation in the laws of England, that whenever a standing rule of law, of which the reason perhaps could not be remembered or discerned, has been wantonly broke in upon by statutes or new resolutions, the wisdom of the new rule has in the end appeared from the inconveniences that have followed the innovation. The doctrine of the law then is this, that precedents and rules must be followed, unless flatly absurd or unjust. For though their reason be not obvious at first view, yet we owe such a deference to former times as not to suppose they acted wholly without consideration. To illustrate this doctrine by examples, it has been determined, time out of mind, that a brother of the half-blood, i.e., where they have only one parent the same, and the other different, shall never succeed as heir to the estate of his half-brother, but it shall rather escheat to the king, or other superior lord. Now this is a positive law, fixed and established by custom, which custom is evidenced by judicial decisions, and therefore can never be departed from by any modern judge without a breach of his oath and the law, for herein is nothing repugnant to natural justice. Though the reason of it, drawn from the feudal law, may not be quite obvious to everybody, and therefore, on account of a supposed hardship upon the half-brother, a modern judge might wish it had been otherwise settled, yet it is not in his power to alter it. But if any court were now to determine that an elder brother of the half-blood might enter upon and seize any lands that were purchased by his younger brother, no subsequent judges would scruple to declare that such prior determination was unjust, was unreasonable, and therefore was not law. So that the law and the opinion of the judge are not always convertible terms, or one and the same thing, since sometimes may happen that the judge may mistake the law. Upon the whole, however, we may take it as a general rule that the decisions of courts of justice are the evidence of what is common law, in the same manner as, in the civil law, what the emperor had once determined was to serve for a guide for the future. The decisions, therefore, of courts are held in the highest regard, and are not only preserved as authentic records in the treasuries of the several courts, but are handed out to public view in the numerous volumes of reports which furnish the lawyer's library. These reports are histories of the several cases, with a short summary of the proceedings, which are preserved at large in the record, their arguments on both sides, and the reasons the court gave for their judgment, taken down in short notes by persons present at the determination. And these serve as indexes to, and also to explain, the records, which always, in matters of consequence and nicety, the judges direct to be searched. The reports are extant in a regular series from the reign of King Edward II inclusive, and from this time to that of Henry VIII were taken by the praetonataries, or chief scribes of the court, at the expense of the crown, and published annually, whence they are known under the denomination of the year-books. And it is much to be wished that this beneficial custom had, under proper regulations, been continued to this day. For, though King James I, at the instance of Lord Bacon, appointed 2 reporters with a handsome stipend for this purpose, yet that wise institution was soon neglected, and from the reign of Henry VIII to the present time, this task has been executed by many private and contemporary hands, who sometimes through haste and inaccuracy, sometimes through mistake and want of skill, have published very crude and imperfect, perhaps contradictory, accounts of one and the same determination. Some of the most valuable of the ancient reports are those published by Lord Chief Justice Coke, a man of infinite learning in his profession, though not a little infected with the pedantry and quaintness of the times he lived in, which appear strongly in all his works. However, his writings are so highly esteemed that they are generally cited without the author's name. Beside these reporters, there are also other authors, to whom great veneration and respect is paid by the students of the common law. Such are Glanville and Bracton, Britton and Flita, Littleton and Fitzherbert, with some others of ancient date, whose treatises are cited as authority, and are evidence that cases have formerly happened in which such and such points were determined, which are now become settled and first principles. One of the last of these methodical writers in point of time, whose works are of any intrinsic authority in the courts of justice, and do not entirely depend on the strength of their quotations from older authors, is the same learned judge we have just mentioned, Sir Edward Coke, who hath written 4 volumes of Institutes, as he is pleased to call them, though they have little of the institutional method to warrant such a title. The first volume is a very extensive comment upon a little excellent treatise of tenures, compiled by Judge Littleton in the reign of Edward IV. This comment is a rich mine of valuable common law learning, collected and heaped together from the ancient reports and year-books, but greatly defective in methods. The second volume is a comment upon many old Acts of Parliament, without any systematical order. The third, a more methodical treatise of the pleas of the crown, and the fourth, an account of the several species of courts. And thus much for the first ground and chief cornerstone of the laws of England, which is general immemorial custom, or common law, from time to time declared in the decisions of the courts of justice, which decisions are preserved among our public records, explained in our reports, and digested for general use in the authoritative writing of the venerable sages of the law.